Good afternoon, everybody. Welcome to the Appellate Division First Department. We have almost 6 hours of oral argument requested. So as you've heard us say before, we have had your briefs and your records and are familiar with the cases. So we ask you please to just ask for the time you really need. If we still have questions when the time is up, we will continue to ask our questions, but we ask that you abide by the light. So when the light turns white, it means you still have 2 more minutes. When the light turns red, it means you should finish your sentence. And as I said, if we still have questions, we'll keep asking them. Okay, so the first case, when I call the case, will the appellants and respondents please stand up and tell me how much time you actually would request, and we'll let you know what we can give you today. Okay, first case, People versus Sean N. You're the, there's no respondent here? Would you still like to argue? All right, we'll give you 2 minutes, and if we have further questions, we'll give you more. Thank you. Y. Michael versus Dawn S. Those 2 cases are submitted. Burroughs versus 75-25 153rd Street. Okay, 7, 3, and 6. I think we're going to have some questions. I'll let you have that amount of time. Ruiz versus Roosevelt Terrace.
I apologize. We did ask for argument on our brief. If I could view the error, I have 5 minutes at the appellant and 1 for appellant.
Now, you are which appellant?
Roosevelt and DJ.
Okay, is the other appellant here? Yes, Your AFP?
Correct.
So you asked for 5 and 1, right? And what are you asking for, AFP? 3 and 1. And respondent? Okay, you 5, 1, 3, 1, and 3. Thank you all. People versus Angel Diaz? Submitted. People versus Edwin Rivera? Submitted. Melrose Associates versus Floral Associates? Appellant, how much time? Respondent? Respondent? Okay, we'll give you 6 and 2 and 6. Thank you very much. Travelers Casualty versus Vail, Canada? 7 and 3. And what about the other Royal and Son? Okay, and who and respondent? Okay, well, you probably noticed we don't give you the full times. So, are you on this case too?
Yes, I am. I represent Players Insurance Company of Wausau and other respondents. I'm not requesting additional time that is available to answer questions.
Right, because didn't you sort of agree with everybody? Isn't that what your brief said? Okay. Thank you. So Vail, Canada will give you 6 and 2, and Royal Sun will give you 3 and 2, and we'll give the respondent 5 minutes. And if you really need extra time, we'll figure it out. Okay? I'm sure that will work out. Thank you all. People versus Silva. Submitted. Leathers versus Approved Oil. Okay, and then the defendant is a cross appellant, right? Okay, so we'll do 5 and 2 and 5 and 2. If you need more, we'll work it out. Alekna versus 207 versus 217 West 110th. Okay. Respond. You got it. 3, 2, and 4. Thank you. People versus Kylester Williams. Respondent?
Respondent requests 3 minutes, Your Honor.
Okay, we'll do 5 and 1 and 3. Thank you. NMRE Tailing versus Oak Investment. That case was argued already this morning at a special session virtually. People versus Angel Diaz. 4 and 1. Is there a respondent here? Do you still want a few minutes to argue or you want to submit? 3 minutes? Okay, we'll give you 3 minutes. Staten Island Care versus Zucker. Respondent? 5 and 2 and 5. Thank you. Sotelo versus TRM Contracting.
Appellate, 5 and 1, please.
Okay. Sure. 5, 1, and 5. Countrywide Insurance is submitted. And Regi versus Charlie Rose.
Good afternoon for the appellate, 5 and 2.
And responded? Yes, that's what we gave you. Okay, thank you. Thank you all very much. That completes the call of the calendar. The first case for argument is People versus Sean M. Good afternoon.
Good afternoon. May it please the court, Hannah Gladstein for the appellant Sean N. Sean was adjudicated a youthful offender, and therefore a sentencing court today would have no discretion to impose any surcharges or fees at the time of his sentence. So therefore, if this court finds that the statute repealing surcharges is retroactive,
Well, haven't we found, I mean, our courts, I know the second department is differently, but haven't we repeatedly in the past year or two found that it is not retroactive?
I think that this court has not found that. I think that this court has exercised its discretion in appropriate cases to repeal surcharges as an exercise of its
Well,
own
we've done it
discretion.
when the people consented.
There have been cases where the people did not consent. Most recently, there was a case a couple weeks ago, People versus Abreu, where the people did not consent. I don't believe the people consented. And Mr. Abreu had been convicted of an attempted murder in this case. This court vacated the surcharge without making any finding about retroactivity. So I can address the equities here that would support an exercise of this court's discretion. It was the intent of the legislature in passing this statute for all youthful offenders, regardless of their offense of conviction or their sentence, to obtain the relief created by this statute. Even for non-youthful offenders, the legislature didn't restrict eligibility based on the offense or the sentence. They created factors that guide the court's discretion.
Does it matter if the defendant commits further crimes after the particular offense and issue that you're seeking the elimination of the surcharge?
No, I think that the appropriate way
And
to
in this case, if I'm not mistaken, he had a subsequent YO finding, correct?
Yes, that's not actually part of the record before this case. The prosecution mentioned that in their brief. My response to that would be if Sean were to come before this court in that subsequent case asking for waiver of the surcharge or vacature, the court could deal with it at that time. But looking at the equities that would have been before the court at this time of this conviction, Sean was a high school student who had not even completed high school. He was dependent on his family for support. He qualified for appointed counsel throughout the pendency of the case below and on appeal, so he's precisely the type of person who the legislature had in mind. And again, he was adjudicated a youthful offender, and surcharges have been entirely repealed for that class of people.
Okay, thank you very much.
Thank you.
Have a good afternoon. The next case for argument is Burrows.
Good afternoon, Your Honors. Deborah Regal from the law firm of Rosenberg and Estes for the appellant. May it please the court, there are two issues before this court that respectfully the lower court erred in denying the motion to dismiss. The first with respect to the application of the statute of limitations to these plaintiffs' claims. The second with respect to the concession claim raised by Plaintiff Waller. So I'm going to start with the overcharge claims. These are claims based on registrations that were filed and have been continuously filed with DHCR since 2007.
And those registrations, did they contain two rents?
So the initial registrations contained both a legal rent and a preferential rent. I won't argue that probably shouldn't have been done at the time, but I will, as we argue in our briefs, take the position that, number one, based on this court—
Public record, right?
They were public record. And those registrations, there is not a time that there was not a registration filed in this case. This case is very, very similar to Reich in the sense that there is nothing that these plaintiffs knew when they filed this case 17 years after the initial registration that either they or their predecessors didn't know or couldn't know in 2007. And what both the Court of Appeals in Regina, what prior CPLR 213A, and what prior RSL 216-516A1 provides is that after 4 years, those registrations are done. They are final. And as this court—
But wasn't the issue here, as I understand it, if you do the preferential rent charging and collection correctly, then at some point in time you have the ability, putting aside post-HSTPA issues, you have the ability to move that preferential rent up to what would have been the registered legal regulated rent, correct?
Theoretically, yes.
Theoretically, so just bear with
Theoretically,
me.
yes.
So if you have the preferential rent and you do everything right, you can move it up. But what if it's not really a preferential rent, but because this is 421A and because HPD sets the initial legal regulated rent back then before registration as the base rent to jump off of, and I'm not getting caught up with the 2.2 allowances and all that other stuff from yesteryear. So essentially, that rent is not a preferential rent, but in fact is a legal regulated rent that is the one that can never be any kind of bridging gaps that we would traditionally see between a preferential rent and a legal regulated rent. Do you agree with that, Ms. Regal?
Yes, if I follow, yes.
Okay, so isn't that the heart, putting Waller aside, isn't that the heart here of their position that by doing so you sort of game the system, but it's argued that it's a gaming of the system and maybe we need a trial to flesh out what exactly were those rents? Is it really preferential? Was it really illegal? And sort of sort it out.
So their argument, based on the complaint, is solely that based on the fact that there was an error in the initial registrations, this court should abrogate the statute of limitations and find that they have met their burden to establish a colorable claim of fraud based solely on those initial registrations.
And what's the specific error that you say they are claiming in their complaint? What's the error in those initial registrations?
The error they are claiming is that there was a preferential rent and a legal rent that was registered in the context of tax benefits where preferential rent couldn't have been collected. But the facts here, which are not in dispute, establish that the legal rent authorized by HPD registered incorrectly as a preferential rent, but the legal rent is the only rent that was charged and paid. But for the
You always
mistake—
charge them the lower amount.
Correct. So, but for a ministerial mistake in those registrations, there is no issue here. And as this court found in 20, was that say last year, but COVID, but in 2020.
Is there an indicia of fraud in that which allows you to get out of the 4-year limitation?
I don't believe so. I think the Court of Appeals in Regina made it very clear that you need more than an error. Not every error by a landlord must be fraud. And that's essentially what they're arguing. And this court said to the contrary in Costick.
Well, you call it an error, but they don't call it an error. They say that it was something that you did intentionally, and therefore they should be allowed to do some discovery, as they put it in their briefs. There's smoke, let's see if we can find the fire. So shouldn't they, because this is a motion to dismiss, shouldn't they be given an opportunity to explore the issues that they're seeking to explore?
So they call it fraud because they have to call it fraud to get around the statute of limitations.
You call it an error because if you call it fraud, then that's the end of the argument.
I understand, but as I was just saying, Your Honor, and I believe you were on the panel in Costick, as this court found in Costick, if the registrations were clear on their face, and they were clear on their face going back to 2007, no tenant could reasonably have relied on that error. And the Court of Appeals in Regina made it very clear. It's not just an error that you have to find. It's not even just a misrepresentation. You have to find reliance, and they could not have relied, and you have to find injury, and they cannot show injury.
What is the alleged benefit to you, an alleged detriment to them in this era?
I think they would say the alleged.
If there was fraud perpetrated, there must have been some hope to get some benefit from it. So what is the benefit that you got out of, that you achieved by this alleged fraud, and what is the detriment to them by this alleged fraud?
I would say there is no benefit that my client got out of this. And I would also point out that my client is a successor owner. So when the Court of Appeals talked about repose, my client purchased this building after the statute of limitations had already run. And when you talk about repose, and you have an owner who looks at
They also make the allegation that by doing this, perhaps what happened is that as there were successive tenancies, you threatened those tenants when their leases came up for renewal that you were going to charge them the higher rent in order to push them out so that you could stir the pot and get more vacancy increases. What is your response to that argument?
My response to that is I think the Court of Appeals has now made it clear that fraud claims and rent overcharge cases are just like any other fraud claims. You don't get to assert fraud based on speculation. You have to specifically plead a fraud, and they haven't done that here, and they had an opportunity. Look, they were outside of the statute of limitations anyway.
Would they have been in a position to present some evidence on this subject? I mean, they're alleging this as to 3 different tenants here. They could have gone to some tenant and said, who is the predecessor, and presented an affidavit that this is what's happened. You were threatened and with the higher rent, and that's why you left, so that they could get the higher increase.
I have any number of complaints in other cases, and I'm sure this panel has seen them, where attorneys have in fact gone to prior tenants and in fact alleged facts.
Is there anything like that here?
No, nothing. It is pure speculation, Your Honor.
Okay, let's hear from the other side. You'll have a few minutes in rebuttal. Thank you, Ms. Riegel.
Thank you, Judge.
May it please the court, Roger Sacker, Newman Ferrara. We heard a lot about Regina, but we didn't hear anything about Thornton. Let me quote from Thornton. An unscrupulous landlord could register a wholly fictitious, exorbitant rent, and so long as the fraud is not discovered, for 4 years, render that rent unchallengeable. That's exactly what their argument is here. That is exactly the argument the Court of Appeals rejected in Thornton. Again, Conanson v. Megan Holdings. Tenants instead advance a colorable claim of fraud within the meaning of grim. That's exactly what we do.
I know you also, I think you cite Drucker also for this point that this is exactly what could be happening. But of course in Drucker, the point was that the landlord was charging a higher rent than he was permitted to charge, right?
Correct, but they're essentially arguing a waiver, right?
Not a case where the landlord was potentially charging less than they could have charged.
No, no, this landlord was never
You
charging
don't
less
think
than
that this?
They were charging, for the first rents, they registered with a preferential and they charged that, right? And then when.
They were entitled to charge those rents, right?
Yes, and that should have been the legal regulated rent. The problem isn't with that first rent per se. The problem is what happens on renewal. Because on renewal, we know this from the DHCR rent roll, they were
It's
taking
your
RGB
speculation,
increases.
it's your speculation in this is that they went to those tenants and said, look, if we're going to charge you the higher rent that we've registered, and therefore those tenants decided to vacate because they weren't going to renew those leases at those higher rents. And thereby they were stirring the pot so that they could get the higher allowances that would occur upon a vacancy.
I mean, partially, but the issue is we know that from the renewals, right?
Am I right that that's sort of the argument that you were making?
We don't know pre-discovery what they were doing. We do know that they were renewing leases at amounts higher than they could have.
So to allege fraud, don't you have to come into court with something more than I don't know?
Substantial evidence pointing to the setting of an illegal rent in connection with a stratagem devised by the landlord to remove the tenant's apartments from the protections of rent stabilization. That's the Court of Appeals.
But for the pleadings, as my colleague was trying to ask you, if there's no dispute that that first rent that was charged when it came into the system, even if the nomenclature, even if it was characterized as a preferential rent, was the actual rent charged and paid, and we know that that was a legal regulated rent factually.
Yes, the preferential rent
Just
should have been legal
bear with
regulated.
me for a second. Let me
Got it.
finish the thought. And that preferential rent was, while not registered as an LLR, but was registered, and we know, at least from what I saw here, that nobody was charged when there were renewals on the higher legal regulated rent, but on the lower preferential rent when it was done. So just, if it was done, so that means there's no overcharge per se, even though I understand what you're saying. Recognize that they should have characterized it accurately in the registration statement. But in the absence of any evidence right now, or any facts, pleaded facts, that the landlord went ahead and used that gap to take that false legal regulated rent and use it as Justice Friedman alleged, is there anything like that?
No, you pause for a second.
Okay.
Remember what happened to that first preferential rent. They may not have jacked it all the way up to the $5,000 legal regulated rent, right? But they still took a 17% increase. That's the problem. If they'd have registered the preferential rent as the legal regulated rent, they wouldn't have been able to do that. Therein lies your problem. These landlords have
So you're
taken-
saying they got whatever kind of rent stabilization, what was permitted, whether it was 2%, 3%, but based on the smaller rent, the preferential rent, it really turned out to be a much larger increase?
Exactly.
And that's what they were paying each year, so the increases were larger.
Right, and so as a consequence, they've taken $33 million from New York City taxpayers and have never, ever properly registered this apartment. That's the problem. They are basically getting to pretend that rent stabilization does not apply to them. And they're arguing it based on this idea of repose. Well, if repose is really the idea, why'd they try and fix this problem in 2017? If they didn't have a problem, they didn't need to fix it,
So they
right?
went back and they tried to, they
They tried to
made
whitewash
changes on
it.
all of
Yes.
the.
Yes, absolutely. One other thing, we heard this argument about error. Well, every landlord is going to say that at the commencement of every case. Oops, I provided a deregulated lease. Oops, I evaded J51. It was just an error. I
So
didn't do
you're
anything wrong.
saying they did collect more rent than they should have been able to collect, and that was the benefit to them for the.
Exactly. There's your benefit, Justice Friedman. That's what you were asking about. That's what we were looking at. Thank you.
Thank you.
So, a couple of points. Mr. Sacker deftly sidesteps the question, which is, What did his client know 17 years later that was not known and knowable in 2007?
Oh, what, I mean, the fact that you went back and fixed all these rent regulation records in 2017, so wasn't that because there was some kind of mistake, intentionally or not? We don't know why.
So in 2017, it's not a mystery. In 2017, there was a new owner. And they.
That's your client?
That's my client. There was a new owner. They did not correct the records to benefit, to obtain more rent. They collected the record in 2017 because they were precluded from going back by DHCR's rules from fixing the initial registration. So they did what an honest, forthright landlord should have done, just like the owner in Reich. They went and they tried to correct the record that the tenants had always had before them. And Mr. Sacker still can't answer the question, why are they not bound by 516A1? And they are. Those registrations were public record. They were clear on their face.
He says you collected 17% more rent.
First of all, that's not in the record. And second of all, I think 2 examples that he pointed to of potential rent overcharges were in 2007, also far outside the statute of limitations. And again, just
So how did
because
those rent overcharges come about?
there was an increase above guidelines. So will I say there was not an error? There perhaps was an error. I don't know. On the face of it, he has pointed out an error. Also outside the statute of limitations, also registered, also clear on the face of the public record,
And that happened
they
in
did nothing.
2007.
And that happened in 2007, and they did nothing.
So you're saying what he's talking about is something which occurred in 2007?
Correct. He's not talking about an overcharge that occurred within the last 4 years for which any tenant would have a right to sue. He's talking, again, about an act that was public record, that was registered, that occurred.
Other than that overcharge in 2007, was there a recurrence of something like that subsequently?
No, and he obtained the entire rent roll for the building, and I can guarantee you that if he had found something, he would have trumpeted it. There is nothing. This was purely a registration error 17 years ago for which he is now trying to hold a successor landlord liable. If I could just briefly.
Which if someone had looked at the public record, they would have been aware of.
Yes, and which tenants are chargeable with knowing. It's the whole concept of record notice, at which this court recognized in Kostick. If I can just say one thing about Waller.
Well, that's the point I was raising. The fact pattern here, we have a 2-month concession that was incorporated into the lease, whereas in Flynn, which you rely on, was a clear concession based on construction, dirt, debris, in that sense. So it's not unreasonable from their point of view to view this lease with Waller as suggesting that it should have been a net effective rental.
It is for this reason. My client didn't have a crystal ball. Distinct from Flynn and Chernette, where there were tax benefits which precluded preferential rents. In 2017, when my client used that concession rider, the HSTPA wasn't a glimmer in anyone's eye. What counsel is saying is he needs discovery to find out if that concession was a pretext.
Well, so
a pretext for what?
Flynn doesn't say you have to have that in the lease.
Correct.
In order to get that benefit. It happens to be that's what the lease said, and this court said, well, that's good, but it didn't say something other than that is no good.
Correct, but even if you don't get to that issue, in 2017, it couldn't be a pretext for anything, because in 2017, whether you called it a concession or a preference, my client was entitled to revoke it as a matter of law. So there's no need for discovery, because what pretext could my client possibly have been engaged in unless it somehow had the superior knowledge to everybody in the world that the HSTPA would arise 2 years later?
And
I'm sorry for the sarcasm.
What value does fact sheet number 40 have to your case?
Fact
To what extent can that be relied upon?
Well, Fact sheet 40, which this court found in Flynn and Churnett, could be relied on, distinguishes between concessions and preferences. And concessions, which this court found was appropriate to rely on, concessions are defined as finite individual months of concession. My client gave a 2-month rent concession, not with any fraudulent reason, as you found in Churnett. They gave a 2-month concession.
Is what your client did consistent with fact sheet number 40?
Absolutely.
But that concession, your client reserved the right to take it away
Correct.
if the tenant did not comply with the terms of the lease. So it was for the whole term of the lease, and the tenant didn't know if he was going to have that concession up until the lease ended.
I don't believe so, Your Honor. I believe that was a flat 2-month concession that was granted, and it was granted in the first 3 months of the lease. If you look at the respondent's brief, in fact, he has a chart where he shows the months in which the concession was granted.
Didn't your client reserve the right to take that concession away if the tenant did not comply with the terms of the lease?
I
At the end of the lease term?
don't believe so, Your Honor.
I believe that's what I read.
I don't have that recollection. I'm happy to check and
So I think that's their argument. Their argument is, once you don't, in reality, have identified those 2 months, and you've made it so that they are revocable whenever you want during the lease, the term of the lease, then it's not really a 2-month concession. It's a net effective rent. It's a preferential rent that you're charging. Therefore, you should not be able to raise the rent above whatever amount it is once you average those months out.
that's actually, Your Honor, it's not an argument that they've raised. What they've said simply is, you can't rely on fact sheet 40. A concession must be deemed to be the equivalent of a preferential rent. And based on the new law, which says that you can't revoke a preference, my client must have been trying to engage in some pretext by calling it a concession rather than a preference so that it would have the right to revoke it. Counsel's not arguing that we made it conditional.
Wasn't that you got the first 2 months, but if you didn't pay the rent, then it was going to go away? Then, wasn't that the provision of it?
If I can grab the record, I'm sorry, I came up without it.
So what was the amount, if you know, the amount of the increase that resulted from that concession? Was it $25 a month?
Well, so at the end of the lease in which the concession was granted, the rent was increased by merely $25. Yes, it went from $39.50 to $39.75.
We'll find it ourselves. We have the record. Okay.
Don't worry, we'll be reviewing it ourselves.
I'm sure you will.
Well, thank you very much. We
Thank you,
appreciate
Your
both
Honor.
of your time on this case. The next case for argument is Ruiz versus Roosevelt Terrace.
Ruiz, this is the case, I'm sorry, but this is the case of the day. Yeah, right. We can find it ourselves, no.
Okay, you represent Roosevelt.
I represent Roosevelt and DJM, Your Honor.
Right, and DJMs. Okay, counsel, you may begin.
Thank you. May it please the court, Your Honors, my name is Michael Caulfield. I'm with Hannum Ferretic, and as I just indicated to Judge Kapnick, we represent Roosevelt Terrace, which is a ground lessee of an apartment complex in Queens, Jackson Heights, Queens, and part of that apartment complex is an underground parking garage. I also represent a contractor by the name of DJM, who in turn contracted with the plaintiff's employer, a company called Sterling. But if I could talk about Roosevelt first and the 241-6 issue here. The way the accident happened is plaintiff is on a scaffold with another worker, and he is using a chipping gun, which is not a battery-powered device. It's plugged in. It's got a wire coming out of it, which in turn went into an extension cord. And he's using that at about eye level or above his head, and he comes in contact with a piece of, depending upon what I believe the jury should decide, is a piece of exposed conduit or rebar or something metal that his deposition testimony caused a shock to him and caused him to fall back.
This basically an unwitnessed accident.
You can say that, Your Honor, because while there was another person, another worker on the scaffold with him who actually caught him and prevented this from becoming a 240 case.
So you're trying to raise an issue as to how the accident actually happened. What evidence is there which supports the view that the accident didn't happen, as the plaintiff says, that he drilled into this conduit and therefore got the shock?
The evidence, Your Honor, is that while at the deposition he testified and described it in the way I just, laid it out for you, when he went to the Elmhurst Hospital in Queens that very same day.
Wasn't there a statement at the Elmhurst Hospital from his boss who did not witness the accident that said something different, but it wasn't from him, was it?
Oh, it's my understanding, the way I read the record is that it said it says patient gave the story and the patient gave it through a qualified language provider. There's no dispute that this plaintiff speaks Spanish, but there's a note at page 808 of the record that the patient gave his information through a qualified Spanish-speaking or preferred language provider. So I think we have a question.
Isn't it the plaintiff's boss, as Judge Kapnick was asking you, isn't it the plaintiff's boss who came in with this version that the shock came from the fact that a wire touched his leg, fell on his leg?
That was from the plaintiff himself.
It's not from the plaintiff's boss?
That's not my understanding, Judge.
I just want to read page 826. Part of it, it says, patient boss states that the patient was working on the ceiling in the garage when a wire fell and hit his leg and shocked him. This is page 826 of the record.
Thank you for your help, Judge. I didn't remember that page number, but that's my argument, that patient states.
No, the boss. It says patient boss states. Yeah, PT boss states.
Right.
826.
Well, the thing is, so even, I'm not sure that can get in, but even if it can, I mean, wasn't there testimony that while the plaintiff was working on demolishing that area, that underground area, that the electricity was supposed to have been shut off because he was working with an electric tool and he hit an electrical conduit, and whether it shocked his hand right away or it shocked his leg, he suffered an electrical shock because there was not supposed to be power on at that time.
But there wasn't, that's everything you said, Your Honor, is correct, but there was another source of power. They drew the power from a neighboring apartment.
Yeah, they had lights strung up, but how does that go towards the electrical conduit? That was supposed to be turned off.
See, because the wire ran down to power the chipping tool that I mentioned earlier. And it was
So the
that
point you're
loose.
trying to make, is that there was a source of electricity appropriately coming into that area, and that's where the shock came from that wire that fell down and hit his leg.
Yes,
But
Your Honor, that's the point I'm trying to make.
As Judge Kennedy read from the record, that plaintiff boss, which appears in the record, what is your theory for how we ought to consider using that to say that there's a variation, that there's an evidentiary variation in how this accident happened?
I would guess it's a difference between a business record and an admission, and this would be, since that statement was germane to diagnosis and treatment, it can be considered by the court. Because it was his left leg versus his,
Even though it was provided by his boss and didn't come from him?
it's still germane to diagnosis and treatment.
They would have
Well, he has-
treated him differently regardless of where the burns occurred or where the I don't see the linkage. How do you explain that to me?
Because the source from the other apartment in the building, I mean, there had to be power in order for the chipping gun to
Well,
operate.
that's obviously not
no, no.
something that the hospital's going to care about. That's what we lawyers care about, not the
Right.
doctors.
That's what I'm trying to say. I'm trying to understand, for diagnosis and treatment, when you have a situation where the biomechanics become important with a torque injury or with certain kinds of injuries, where the doctors need to know how an accident happened to possibly see what happened here. If he was electrocuted, regardless of the source of that electrocution, they're treating the electrocution. They don't care why or how, they're treating it. So how could it possibly be for diagnosis and treatment? Hence, as was pointed out, there could be a real issue whether comes in because it's hearsay and not really part of the regular duty of making a business record for purposes of this hospital record.
Judge, I would suggest the difference is because it's versus the ungloved hand, which is another issue, which versus the left leg, which I believe is what Elmhurst Hospital talks about.
Would how he's treated be affected by whether the electrocution was in the arm or whether it was in the leg? Is that something which would be of interest to someone providing medical treatment?
I would think so, Your Honor. If I shock my left hand versus my left leg, I think so. I'm not a physician or a medical expert, but I think it's relevant or germane.
Okay, why don't we hear from the
Thank you.
co-appellant, and you'll have some time on rebuttal. Thank you.
Good afternoon, Your Honor. Seth Weinberg with Marlowe, the party for AFP. And I would direct the court's attention not to page 826, but page 802 of the medical records, which says, quote, patient claimed while at work, a loose electric wire shocked him on the left leg. That's not a statement attributed
That's
to the
also
boss.
in the hospital record?
Correct. So plaintiff is taking the position, well, that must mean the person who took the note just somehow ignored the part about the boss in writing this note. But that's not for this court to decide as a matter of law here and now. If there's conflicting statements in the record, one of which is directly attributable to the plaintiff, and it is relevant to diagnosis and treatment for this reason, plaintiff's claim in this case is not for electrocution injuries. It's for orthopedic injuries because he's claiming that the chipping gun caused an explosion that knocked him down, causing him to injure his back, leg, etc. And when he went to the hospital, he wasn't treated by orthopedists. He was treated by cardiologists because they thought he got a jolt of electricity to his body. So that's why this statement is a statement attributable to plaintiff that was for the purposes of care and treatment, diagnosis and treatment. It is therefore an admissible business record.
And that puts an issue whether or not this occurrence is a result of him having drilled into an electric conduit to which the power was supposed to have been stopped, and the allegation is that it wasn't shut off, and this alternative version that it came from a source of electricity which was appropriately left on.
Correct, because, Your Honor, the code only limits where electricity was supposed to be turned off in certain areas. So if he was hit by a loose wire somewhere else on the site, the code may not apply to that.
But wasn't he standing on the scaffold working above him at the time of the accident?
Well, again, that's what he testifies to, but he told the
Well,
providers.
there was somebody else working with him on the scaffold.
Person's never been located, Your Honor, hasn't testified. So this is essentially an unwitnessed accident. And what the Court of Appeals has held is, yes, unwitnessed accidents are sufficient to meet a prima facie burden unless there is a credible challenge to the credibility. And we have that here. So if we have this statement attributable to plaintiff, this now becomes for the jury to determine, plaintiff, which version happened? Were you electrocuted by a wire somewhere, like you're saying at the emergency room and you got a cardiac workup for and you went home without orthopedic treatment? Or was there this electrical caused explosion, like you testified to, that knocked you over and you told nobody about at the hospital?
I mean, the hospital record reflects him saying that he was struck by a wire.
Again, I'll read the quote, Your Honor. Patient claimed while at work, quote, a loose electric wire shocked him on the left leg, close quote, denies LOC, close quote. So that's at page 802. It's under chief complaint. It says complaint, electrical shock, there's a medical code number, then the comment, which is what I read to you. The court has no other questions. We'll rest on our brief.
Thank you, counsel.
Thank you.
May it please the court, my name is Judah Cohen and I represent the plaintiff respondent in this case. As the court has already noted, no power was supposed to be on at that premises whatsoever, and therefore the plaintiff had no expectation.
So what was the power that was going to power the tool that he was using?
The power tool that he was using was connected to an extension cord that ran underneath him to the scaffold as gravity takes the electric cord down and he's up on a Baker scaffold.
So there was power coming into the premises.
It was extended by an extension cord.
Wait.
It was appropriate for power to be coming in because how else was he going to use the tool?
That's absolutely correct, Your Honor, but plaintiff specific in his testimony on multiple occasions that the conduit that he came in contact with the power tool that he was using, was above his position and it was encased in concrete. It was not some other dangling wire.
How does that square with what appears in the hospital record at page 802?
Page 802, Your Honor, is in direct conflict with what Justice Kennedy said, and therefore these particular hospital records...
If there is that conflict in the record, and what's said at 802 is something which would seem to clearly be something which could be used on a motion for summary judgment, is it for the court to make that determination of credibility, or is it for a fact finder?
That's only if, in fact, this particular hearsay records had other indicia of some truth from some other admissible evidence. You cannot rely only on this inadmissible hearsay record alone to defeat the motion for summary judgment. It has to be coupled with something else. And when it is not coupled with something else, then the record is inadmissible.
What the plaintiff tells his health provider after he's brought in for treatment is not, and when it's germane to treatment, is not something that can be considered?
Well, we don't know if this is particularly germane to treatment. In fact, I would even posit that
whether he was shocked in the arm or shocked in the leg something which is germane to treatment?
No, as the co-appellant did point out, he is coming in there and his chief complaint the entire time, as he testified, was pain in my leg. And in fact, the ultimate diagnosis, which is in the record, by the way, at page 829, is left leg gastroesophageal complex and secondary to electrocution, which is consistent with the fact that he complained that he felt pain in his left leg. But be that as it may, it is not germane to diagnosis and treatment whether the wire was dangling or not, rather only that they heard that there was an electrocution. Now, when the appellant says, for instance, that there's a qualified provider that speaks the patient's preferred language at the record at 808, well, the record at 829 also says that patient needs a translator. In those very same records, we don't know who the declarant is, of who's writing down these records. They're not certified, these records, and they submitted them in opposition to our motion for summary judgment. The case that they particularly rely on from this particular court...
Okay, can you wrap up?
Pardon?
Can you just wrap up, because you have run over your time?
Thank you, Judge Kapnick. Our position is that particular medical record is inadmissible hearsay. The glove is a red herring. He had no expectation, and the lower court was absolutely 100% correct in ignoring these feigned issues of fact. Thank you very much.
Thank you,
decision
counsel.
should be affirmed.
Thank you, counsel. Each of the appellants has 1 minute for rebuttal.
First, I just want to apologize to Judge Kennedy as she was reading from page 826. I was hearing 802, which has already been expressed to the court. The only other thing I want to mention in my last minute is the sole proximate cause issue pertaining to the glove. I'd ask the court to consider that as a question of fact on sole proximate cause, specifically to plaintiff's failure to wear the glove at the time of the accident. I have nothing further. Thank you.
Thank you. Counsel? Wait.
Two very brief points, Your Honors. Number one, the statement in the chart is not inadmissible hearsay. It's an admissible statement in a business record. Therefore, the test counsel was relying upon is the incorrect one. And with regard to diagnosis and treatment, it's not merely electrocuted leg, arm. Electrocution at all, explosion, and a fall.
But I thought he said that really, or someone said that he was really going in for a back or an orthopedic injury, so did it matter just that he was electrocuted? They were checking that out, whether it hit his leg, hit his arm?
He wasn't, my understanding of the record is he wasn't treated for the back. He was seen by cardiologists. They were treating him because they thought he took a jolt of electricity. That's
What about the complaint? What kind of injuries is the complaint?
orthopedics, back, neck.
That's what he's seeking?
Yeah, there's no burns, electrocution injuries. Those are the claims. If the court has no other questions, we'll rest on our brief. Thank you.
Okay, thank you. Thank you all. The next case for argument is Melrose Associates.
May it please the court, my name is Alan Bodner, and I represent the appellant Melrose Associates in this case. This case basically has to do with the counterclaims of Floral Associates that certain payments were coerced by Melrose in order to obtain approval for the sale.
But is something like waiver or latches the sort of determination which this court is going to make on a 30-11 motion?
Sorry, sir, Your Honor, I didn't hear.
You bring up the subjects of waiver
Yes.
and latches. Is that the sort of thing that this court is going to decide on a 30-11 motion?
Absolutely, because the law is, I believe, that it's not whether a complaint was stated, but whether there is a cause of action. And every state, I think, in the United States has held that any objection to coercion has to be made promptly. And this certainly was not done here. It was never made until the answer was filed. And the reversible error from the court below was when the judge stated that the time to make objection is when the answer is served. But I do not believe that is the law. The cases abound in Massachusetts that even 4 months after the event happened, it was too late to make the objection. And the reason is because they do not want the complainant who says that there was coercion to have to decide later on whether they want to make that objection or not. And that was done here. Exactly. They waited 32 months to make any objection. It did not appear until the answer was served. And now the defendant has totally pivoted and says that the counterclaims have nothing to do with coercion. This is absolutely not so, because in its answer it stated that the counterclaims were coercive conduct. That's on page 122 of the record. And also, in the counterclaims themselves, they refer to coercion. That's simply what this is about. And I do not believe the defendants can pivot from the fact that they did not object to the coercion until they had to file their answer. Now, they also had other ample opportunity to do so when in a motion to dismiss, they could have had an affidavit from the attorney who represented them at the closing saying that if they thought so, that the plaintiff coerced the defendant. Absolutely silent about that. Never anything in the record that there was coercion until they had to file the answer. In addition to which, on December 11th, 2019, the attorney for the plaintiff voluntarily submitted mutual releases saying that this is voluntarily entered into. And we're not saying that settled the case, but it shows that the defendant wished to settle the case by giving up its claim for coercion on the counterclaims. In addition to which, the defendant claims that the appeal is only on the counterclaims. This is not so, as the order appealed from is on the entire decision below, including the dismissal of certain of the affirmative defenses, which all lead into the counterclaims, which are nothing but a claim of coercion. The fact that the defendant may have pled a cause of action and has good pleading is irrelevant here. The question is whether the defendant has a cause of action. We believe, Your Honor, that there is no such cause of action, basically because the coercion should have been objected to and was not. And thank you, Your Honor.
Okay, thank you. You'll have a couple minutes on rebuttal.
May it please the court, Michael Schoenberg from the law firm of Ruskin, Moscow, Faltacek for the respondents.
So you, wait, he's making.
I'd like to introduce Mr. Chang from the law firm of Sharon and Logan from Boston and ask that he be permitted to participate in this appeal.
Well, if you came all the way down from Boston, I'm certainly going to let you argue in our court. So
Thank you, Your Honor.
welcome. Good afternoon, Mr. Chang.
Thank you, Your Honor.
Mr. Chang, if I may, counsel talked about a release in 2019, but I was under the impression that there's no agreement.
There is no agreement, Your Honor. We're a little flummoxed, to be honest, about that argument. At one point, the party, let me just be precise about this, Floral Associates was my client, and the respondent did forward a draft settlement agreement because they wanted to wrap things up and settle the parties' dispute. That agreement was never signed. Moreover,
Your point that you're not going to be bound to an agreement which is not signed. But your counterclaims are premised on coercion or duress, correct? That's the underlying basis of your counterclaims, although it's not termed as a counterclaim for coercion. I think it's page 81 of the record, subparagraph E. I regret I don't have it in front of me. So the way this was set up between Floral and Melrose, in order for Floral to sell, which you wanted to sell because there was going to be a significant profit emanating from the sale, you had to get Melrose's consent to the sale. The agreement under which the parties were operating provides that you must consent, and you come to them for consent, and your complaint is that they held you up in order to obtain that consent between the two entities that we're dealing with for a total of $750,000. Now, correct me if I'm wrong. There's nothing in your agreement which says that that consent cannot be unreasonably withheld. How can you have a claim for coercion or duress when Melrose exercises a right which it had to exercise?
as a threshold matter, Your Honor, there is no claim for economic duress. Let's be clear about that. That is a straw man argument, okay? I can only, we have written this.
So what is it that you say Melrose did wrong supporting your counterclaims?
Breach of the covenant of good faith and fair dealing. The important part, Your Honor.
In what way?
If I may complete the argument, which is unlike the cases that my brother has argued. Those are cases where the agreement governing the parties' relationship was being, they were trying to nullify that agreement.
In our case, there's the underlying partnership agreement which governs the relationship between the parties. Part of that underlying agreement, which is the Floral Associates Limited Partnership Agreement, there is an associated covenant of good faith and fair dealing. Under Massachusetts law, you cannot withhold permission or exercise something that prevents the other party from enjoying benefits of that contract.
Shouldn't that provision on page 81 have said the sale is subject to consent, which may not be unreasonably withheld?
Your Honor, it's one of those things, if I could go back and redraft a lot of documents, there would be no disputes. The language is what the language is. But more importantly, the law is the law.
What bad faith is there if they took the what bad faith is there if they took the position, look, we don't want to sell. No matter how much profit you're getting today, 2 years from now we're going to get a better profit. We don't want to go along with the sale. They obviously were given the right to consent without limitation, and they don't even have to provide a reason for why they're not consenting. So how could there be a breach of the covenant of good faith and fair dealing when the very contract under which you're operating gave them a right to do that which they've done?
If it was done, Your Honor, part of the presuppositions of this entire argument is that there was, whether it's done in good faith or whether or not there were other reasons that were behind what happened. So let me give you an example. ESMC, which has nothing to do with the Floral Associates Limited Partnership, received $250,000. What that has anything to do with the permission by the Melrose Associates Limited Partnership?
Didn't you need ESMC to facilitate the consent coming about?
Your Honor, honestly, we're trying to figure...
Wasn't ESMC the entity which had to go to the parties and get them to consent?
That's an excellent question, and that's why we need discovery. We're trying to figure out what ESMC's relationship is with this entire transaction, why they got $250,000.
Well, you paid them. Well, you paid them without objection at the time. So I don't know why that question is pertinent.
Your Honor,
but again, where is the breach of the covenant of good faith and fair dealing when a party to a contract exercises the right which the contract gives them?
That's why this is not a breach of contract claim, Your Honor. It is a claim for the breach of the covenant of good faith and fair dealing.
Yeah, but we know that that's a tough thing sometimes to prove, because if the contract allows somebody to do something, then you can't say, oh, that's a breach because the covenant allowed them to do that. So it's a...
We understand that, which is the reason why we believe we're entitled to discovery. We are taking discovery. And if this, to be blunt, this is really more appropriate for a summary judgment motion, not a motion to dismiss. And that I believe is the best answer for Your Honor. And, you know, there is a difference between exercising contractual rights.
Counsel, I'm sorry to correct you, but the best answer for me, and the reason, my problem with the position that I've asked you about, is that the appellant doesn't make this point until their reply brief. So that's your defense to this. What I'm asking you about is in the appellant's reply brief. That's the first time it's raised. This fact that they had a right not to consent. It may not be it may not be artfully stated in the reply brief, but they do not raise this point until their reply brief.
Okay, thank you very much. I think we got your points. Counsel, you have 2 minutes for rebuttal.
I'm sorry for correcting you, but...
Your Honors, I waive my rebuttal time.
Any questions for counsel? Okay, thank you very much. Thank you both. Have a nice afternoon. The next case for argument is Travelers Casualty versus Vail, Canada. Justice Friedman is recused from that case, and in the event of a tie, we will follow the appropriate rules. Good afternoon.
Good afternoon, Your Honors. Alex Hardiman for Appellant Vale Canada Limited. May it please the Court. Vale Canada respectfully submits that the motion court's denial of the motion to dismiss based on forum non-convenience and CPLR 3211A4 was an error. This is a case that was brought by a Connecticut insurer, Travelers, against a Canadian insured, Vale Canada, regarding coverage for environmental claims and remediation costs.
Well, but this particular case has a lot to do with all the insurance policies, and Judge Barak went specifically through many of the provisions or elements that are brought out by the Court of Appeals in that Islamic Republic versus Pahlavi, which I cited many, many times in writing decisions in Supreme Court. And the court has an awful lot of discretion to weigh all those different factors and determine whether or not there is a forum nonconvenience claim or not. And the court, despite what there has been argued, doesn't have to go through every single factor. I mean, it includes all these factors. Went through all these factors and made this determination. Why is that an abuse of the court's discretion?
It's an abuse of the court's discretion, Your Honor, because the court misapplied the factors and got the facts wrong.
Like what?
So, for example, the court stated that notice of claims were to be provided in New York. That's on record at page 17. That is inaccurate. There is no policy that required notice of claims to be provided in New York, and respondent insurers do not contend otherwise. Secondly, the court stated that certain of the cross claimants here, for insurers, were all located in New York when the policies were issued. Again, incorrect. At least two of the four cross-claimants, North River and Wausau, they've never contended they were in New York and in fact weren't. There are no New York insurers involved in this case. No New York residents, either for Vale Canada, and no New York residents on the insurer side.
Was Vale Canada headquartered in New York at the time that these policies were issued?
It was not, Your Honor. Vale Canada had a subsidiary in New York, Inco Inc.
Inco?
Yeah, Inco Inc. Its parent, now known as Vale Canada Limited, was then known as Inco Limited of Canada.
And it was headquartered in New York at the time?
No, Inco Limited, which is now known as Vale Canada, was headquartered at the time in Canada.
But it had a subsidiary in New York?
It had a subsidiary in New York, and what respondents have focused on is the fact that the insurance manager, long since deceased 50 years ago, unfortunately, was located in a New York office here. But the headquarters of Inco Limited was and always has been in Canada. And that's consistent with the fact that the sites at issue here, all of the environmental sites, not a single one of them is in New York.
But they're in Canada, Wales, Japan, Indonesia, they're all around.
There are 22 sites in Canada and 4 sites in other foreign jurisdictions. And for the purposes of forum non, we're looking at whether there's a nexus to New York. There is no nexus to New York here. The claims, the underlying claims, are all overwhelmingly centered in Canada.
I believe that the judge also pointed out that the broker, the insurance broker, was the New York office of Johnson and Higgins. Now, I know this was a long time ago, but these insurance policies were gotten a long time ago.
That is another error by the motion court, Your Honor. Not all of the policies at issue in this dispute were, in fact, issued in New York. 25% of the traveler's policies, the plaintiff, the excess insurer that brought this action in New York, 25% of those, they admit, were issued through a Canadian broker in Canada. The primary insurer, RSA, an appellant in this matter, is a Canadian insurance company. They issued the primary coverage in this, to which travelers sits excess. All of those policies, 33 years of those policies, were issued in Canada through a Canadian broker. So again, we respectfully submit that the court, that the motion court was in error on that basis as well.
Counsel, if I may, the issue is whether or not there is coverage under certain policies, correct?
Correct, Your Honor.
All right, let's go a little step further. So many, if not most, of those policies, right? They were brokered, they were underwritten, issued, and delivered in New York. Is that a yes or a no?
Many of them, yes, Your Honor.
Okay, so let's take it further. So how is that not a connection? Why isn't this an appropriate form?
It's a connection, but it's not a connection that has any relevance to this dispute, because this dispute...
The dispute is about coverage. Coverage of policies where most were, as I said, they were brokered, they were issued, they were underwritten, they were delivered.
But it's not a question, there's no contract formation issue in this, in this matter. So there's no evidence or documents in New York. There is certainly a connection of this case to New York. Some of the policies were issued in New York, no question about it. But that single factor is not enough to outweigh all of the other contacts in this matter which are overwhelmingly centered in Canada.
Okay, let's hear from your co-appellant. You'll have a few minutes in rebuttal. Thank you.
Good afternoon, Your Honors. May it please the Court, Michael Zhu, Appellate Counsel, the Grande Legal Consultants, attorneys of record for Royal and Son Alliance. My client is a Canadian insurer. My client issued all the primary policies starting from 1968 to 2001. Not one of those policies were brokered, underwritten, issued, or delivered in New York. There's no dispute about that. On page 168 of the record, an affidavit from Brad Keene, who works for RSA, explicitly states that brokerage companies that brokered for these policies were all located in Ontario, Canada. That's paragraph 11 of his affidavit. Paragraph 12 of his affidavit states very clearly that all the policies that are underwritten by RSA were brokered and delivered to Inco in Ontario, Canada. So as far as RSA is concerned, and we made a separate motion to dismiss based on Form 9, there's zero contacts with the state of New York because RSA is not licensed to sell insurance, has never applied for or solicited for business in New York, owns no property in New York, has no bank accounts in New York, has no offices in New York, has no employees, directors, or officers in New York. Looking at this
Counsel,
from another...
did you raise that argument below?
Absolutely. Absolutely. And so the motion court erred in, I'm going to put this in quotes, in lumping us in together with the other insurers who did issue policies and did deliver policies to New York.
I just want to take it a step further. So I was under the impression that you had informed the Ontario court that you, meaning RSA, cannot and has not challenged the jurisdiction of the New York court.
That's for personal jurisdiction purposes, not for forum non, which is a separate basis for the motion, which is why in the notice of motion, we only moved on forum non.
I see.
But I know I did ask to search the record because, honestly, the factors are all the same. If you look at the contacts as a test for forum non, it's the same test for personal jurisdiction. And that's the only reason why I asked the court to search the record. But for the purposes of this argument, I'm here to just argue the forum non dismissal because the motion court held that we failed in our burden to show that Travelers' choice of forum was improper because they showed that policies that were issued by RSA were brokered, underwritten, and delivered in New York.
So can you give me the exact page in the record where you made the argument that you're making now?
Sure. Okay, through Brad Keene's affidavit, page 168, paragraphs 11 and 12, and in the motion papers below, I just have general cites for the for our initial moving and reply papers. If you'd like that, I can give that to you. The motion papers, 32 through 37, are where the arguments were made by RSA in support of its motion for dismissal based on Form 9.
Thank you.
Okay, we're going to hear from the respondent now, and then you have a couple of minutes in rebuttal anyway, so you can, speak further towards that. Thank you.
Thank you.
Good afternoon, Your Honors. Greg Bruno from Day Pitney on behalf of the respondent travelers.
Wait, you're with,
Yeah,
why are you standing
I'd
up?
like to introduce my colleague, Ms. Manis from our
Okay,
Hartford,
you
Connecticut
also
office.
okay.
She's been admitted pro hoc vice and
Okay.
request that she.
There are so many attorneys listed on these, I was not sure. Okay, very good. So, thank you and welcome.
Thank you, Your Honor.
Thank you, Your Honor. My name is Kathleen Manis. I'm with Day Pitney in Hartford, Connecticut, and I represent the Travelers Casualty and Surety Company.
So we've just listened to both of the appellants arguing strenuously that Judge Barak made lots of mistakes in his facts and his evaluation, and they have nothing to do with New York, pretty much. So what do you have to say about that?
Your Honor, and the same lawyers made the same arguments in front of Justice Barak, and he very aptly went through the entirety of the record, which I believe was over 8,000 pages, and came to the right decision, which was that, in fact, notwithstanding the arguments of counsel or the statements made in brief, the actual record evidence in this case is that Valet Canada, which they call themselves now, but actually Inco, whether it be Inco Limited or its subsidiary Inco Inc., had substantial and significant connections to New York, purposely availed itself of the insurance market in New York to procure coverage not just at the primary layer, but all the way up through the towers into the very high layer access, made a very complicated insurance program where they had separate primary coverage for certain geographies, so primary coverage through RSA for Canada, primary coverage through Travelers and through Wausau for the United States operations, primary coverage for its Indonesian operations, its UK operations, and its Wales operations through other carriers. One is allegedly St. Paul. Policy hasn't been located, and St. Paul denies that such policy was issued at this point. And then above those coverages were all the excess policies. And the excess policies, including the travelers' policies for the worldwide operations, were not Canadian-specific. This was not a Canadian-specific or Canadian-centric program. The travelers' policies that Travelers seeks a declaration with respect to its rights and obligations for Valet's environmental sites located in Canada, in New Jersey, and elsewhere in the world, including, as Your Honor pointed out, Wales, UK, Indonesia, Japan, and by the way, not just Ontario, but Ontario and Manitoba, which is different, that the rights and obligations with respect to those policies which were issued in New York, and there is no dispute that the policies, all of the policies, were underwritten by the New York office. They may have been in part the 25% Mr. Hardiman refers to. There may have been a few outliers that were actually delivered, were issued in the name of the Canadian subsidiary or the Canadian company. But those two were underwritten, negotiated, procured out of New York, and in fact contain the majority, if not all, contain a New York address. And this is all about, as Your Honor pointed out, when you asked the question, Mr. Hardiman, which was, what's the relevance of the connections? And he said nothing with respect to the policies. This is not about the policies. This entire dispute that we're here before Your Honors is about the application and the meaning of insurance policies that were executed, issued, negotiated, sold, brokered in this state.
Well, what about the co-appellant who, a Royal and Son Alliance, who seems to indicate they have nothing to do with New York, and they issued all the primary policies, or at least that's what he said, I believe.
Right, and they didn't issue all the primary policies. In fact, Travelers issued certain of the primary policies, and Wausau, another co-defendant here who has asserted cross-claims against Valet, also issued certain of the primary policies. And the primary policies, notwithstanding...
But he said he didn't have, he said his client, Royal and Son, has no connection to New York. Is a Canadian insurance company. They didn't issue anything here. They didn't broker anything here. Nothing went through New York. Is that in fact
I don't know
true?
that that's accurate, Your Honor. In our brief, we set forth in a footnote that some of the RSA policies actually list the New York address for INCO on the policy itself. So I'm not sure that one, looking at the record, would conclude that the RSA policies have absolutely no connection to the state of New York. I know that that is their argument, but again, I would point Your Honors to the record, which Justice Brock had in front of him, where there is an address for INCO in New York contained within the RSA policies. But leaving the RSA primary policy to the side, the other thing I wanted to point out and clarify, because this is a mischaracterization that's contained in both RSA's and Valley's briefs, they try to overstate the significance of the RSA primary policy in the context of this dispute. And they reference the fact that certain policies may follow form to certain terms and conditions contained in policies. I want to make very clear for Your Honors that to the extent any of the excess policies follow form to any other insurance policy, it is to the umbrella policies that are not issued by RSA, but are in fact in many years issued by Travelers, policies that were issued here in the state of New York. And so with respect to the entirety of the program, including RSA, the entirety of Valet's insurance program, how it went about securing coverage through the market, largely in New York, for its worldwide global operations, sites located throughout the world, that has an incredibly overwhelming, significant connection to the state of New York. And Justice Brock's decision is absolutely correct in that regard.
Any other questions? Okay, thank you.
Thank you, Your Honors.
Counsel, you have 2 minutes in rebuttal.
Your Honor, there's a premise here which ran through counsel's argument that is not the right one. This is not about worldwide, this dispute is not about its worldwide operations. This dispute is about 22 environmental sites that are in Canada, 4 additional environmental sites that are in a couple of foreign jurisdictions and New Jersey.
So it's not, this is not an insurance dispute, this is something else?
No, it is an insurance dispute, Your Honor, but it's not about worldwide operations. And if you look at the Cadillac Fairview case, this court's case, Cadillac Fairview case, Avnet, the Avnet case, those are on all 4 squares with what we've got here. With there, the court, despite the issuance of policies in New York, and in the Cadillac Fairview case, they were all issued in New York, this court rejected New York as a forum in favor of California and put primacy on where the sites are. And there's a reason for that, because that's where all the evidence is, that's where all the coverage defenses are going to be determined, because it's the facts of those sites. When was the environmental pollution? When did it occur? Did it occur suddenly and accidentally? You know, what are the underlying plaintiffs? There are 6 class actions that were brought in Canada, no claims in New York by any New York citizens, by any New York. There were no sites in New York. So, and Canadian.
So where are those cases? Are they in Canada?
They're in Canada, Your Honor.
They're pending still, those cases?
Those cases are not pending. They're not currently pending.
So they're already decided, and now it's just all the insurance companies fighting with each other?
Those are decided, Your Honor. The Canadian regulators, however, have and continue to issue remediation orders in connection with the sites in Canada. And so it's going to involve coverage questions as to Canadian regulations, Canadian law, and as we set forth in our brief, Canadian law is likely to apply
Well, yeah, no, I understand that, and I know that Judge Barak did address that and indicated that certainly in the commercial division in New York County, we're used to dealing with law from all over the place, so he did deal with that, but I understand your point. Let's hear from your co-appellant. Thank you very much.
Just very briefly, on the issue of a New York address appearing in some of the policies for RSA, that's not evidence of underwriting or delivery of the policies. There's no policy here, and stating that as an issue, as a matter of fact, through Brad Keene's affidavit, there are no policies issued by RSA that were brokered, delivered, or issued in New York. They're all issued in Ontario to brokers that were based in Ontario. As to Justice Kennedy's question, the arguments were raised by RSA in our motion papers and in our reply memorandum of law. So if the court wants, I can submit a further citation, or I could pull my laptop up now to get the cites from the record in terms of where in RSA. But these arguments certainly were made below.
Okay,
Thank
well,
you.
we all have the record, and we'll certainly take note of that. Okay, thank you all very much. Have a good afternoon. Next case for argument is Leathers versus Approved Oil.
Good afternoon. Gail Kellner for Plaintiff Appellant Estate of Leathers. In this appeal, we quite simply seek partial summary judgment on the issue of liability against defendants for the defendant's admitted failure to see the decedent, who is in the third lane of moving traffic at the time that the impact occurred, amputating her foot, leaving her foot in a boot in the crosswalk, and leading to her death. There's been a prima facie showing of the driver's admitted failure to see. He admitted on multiple occasions at both his DMV hearing as well as his deposition that he did not see the decedent. His excuse was that she darted out from behind a white box truck that was in the traveling lane next to him. However, a video, which I am hopeful that you have all had the opportunity to see, showed that there was no box truck that was in any way a participant in this action.
Ms. Kellner, does the fact that the plaintiff, the defendant, had a green light for moving traffic and that the plaintiff went across the road against the pedestrian don't walk sign, how does that, what effect does should that have on our decision?
This is a motion made under Rodriguez versus the City of New York, which holds quite clearly that any issues of comparative negligence would remain for the time of trial, but that there could be a finding against the defendants for their negligence. I don't think it was ever 100% established that the signal was green, but even if it were, that would merely go to comparative negligence.
Well, if we look at the video that was provided, and I certainly looked at it, you can see that there's moving traffic on the road where the defendant is operating his truck.
There was no traffic, Your Honor.
There was moving traffic.
The white van was not at the accident site.
I understand.
I don't think he's talking about the white van. Just let the judge finish his question.
There's traffic is moving on the Bruckner, right? And traffic is stopped on East 138. And your client is crossing the Bruckner. She's going, I believe, west on East 138th when she goes across the street. So if traffic is stopped on East 138, they had the red light, and the light was green for traffic on the Bruckner.
First of all, Your Honor, even what I'm saying is that even he admitted, the driver admitted that he had an unobstructed view of the intersection, which would include the crosswalk. There was nothing impeding his vision as he headed beyond where the white box truck was. And this happened in the third lane of moving traffic. He admitted he did not see her, but what the video has established is that, and the court below understood this, is that this white box truck was not in any way an element in the accident. She did not dart out from behind any other vehicle. This vehicle was not involved, and the court below understood that. The court stated that there was, in the absence of this box truck, no non-negligent excuse for his failure to see the decedent as she was crossing the street. He stated on multiple occasions, I didn't see her, I didn't see her, I had an unimpeded view of the intersection, but I didn't see her. She's in the third lane of moving traffic. There is an obligation, a common law and statutory duty to see that which was there to be seen, regardless of whether the light was against the pedestrian. It is an obligation and a prima facie showing of the defendant's negligence that he did not see her. He made up an excuse. He said, oh, the box truck, she darted out from behind it, giving me a second to see her. But the box truck was not a participant. She did not dart out from behind the box truck. The accident happened at the south end of the intersection, not where the box truck was, at the north end of the intersection. So regardless of the traffic conditions at the north end of the intersection, it had nothing to do with what occurred at the time of impact, and there is no question that the video does not actually show the impact. What the video shows is it shows the truck proceeding into the intersection with the defendant's admission that there was nothing that was blocking his view as he proceeded with traffic. There were no impediments. Nonetheless, he repeated over and over again, she darted out from behind the box truck.
Okay, let's hear from your adversary, and you'll have some time in rebuttal. Thank you.
May it please the court, my name is Nicholas Herzler. I represent the defendants in this case. Your honors, first of all, plaintiff's motion is untimely. They have no good cause excuse for that, number one. Number two, the video is totally inadmissible. They cross-move without establishing in any way that it's admissible at all. Number three, they don't even say how much, this whole case is how much time our driver had to react. They never say how much time, how many seconds he had to react. This box truck was involved. Because even with Belizzi's measurements, you have 104 feet. They make that sound like a lot. 104 feet is 2.5 seconds when you're going 29 miles per hour. That's not a lot of time. And this court has said in numerous cases, such as Ramirez and Pripcan, which we cite in our brief, 2 to 3 seconds is not a lot of time to react, and a defendant is entitled to summary judgment on those facts, especially under the emergency doctrine. We've got somebody wearing dark clothing, under an overpass, there's columns, he had no...
You have a lot of facts there. You have a lot of facts there.
I'm sorry, Your Honor?
There are a lot of facts that have to be determined, right? The first thing we have to do is believe that what your client is saying is the truth. We got to make a credibility determination here because there are a lot of conflicting, there's a lot of conflicting information.
Your Honor, it's our position that with or without the video, first of all, the video is not admissible, but even if the video comes in, we still think that Deeb's testimony is consistent with it and that it shows that he didn't have enough time to react. But I want to speak to what Your Honor just said. If the court were to affirm this order, we still think that it should be modified to the extent that because it's undisputed the decedent was negligent per se in violating about 4 VTL provisions that we put in our brief, defendant is entitled to summary judgment under Rodriguez.
But even if that's so, isn't there still an issue of fact, even if there was partial summary judgment in your favor, isn't there still an issue of fact whether your client was speeding, isn't there enough in the record to create that issue?
Well, what I'm suggesting is that if we're entitled to summary judgment, then under that hypothetical,
You're suggesting you're entitled to partial summary judgment for the violation of crossing against the red light, but no matter what, doesn't there remain an issue of fact as to whether you are, on comparative, whether there was, your client was speeding?
well, we submit that's not the case, Your Honor, because we have it was 30 miles per hour, and the testimony and the evidence is that we were going under that.
Is there other evidence that it was 25 miles per hour?
Plaintiff submitted for the first time in reply a photo of a sign that says 25, however, that refers to traffic turning left as shown by a Department of Transportation map, which we submitted, which indicates that that's the city default limit. If you're on the Bruckner, you're going 30, that's the limit on the Bruckner. If you're going straight, which our driver was, if you're turning left onto 138th Street, that would be the default city limit, which is then 25. And that's based on the DOT map, which is consistent with our position and inconsistent with what plaintiff says, and they never explain that part. That was all submitted in surreply. So on this record, there's nothing to show that our driver was speeding, and they never submitted anything prima facie in their cross motion to show that he was speeding. And by the way, as I said earlier, their cross motion was untimely. And their entire position is based on expert affidavits, which are based on a video, which is not admissible. They have to.
Why do you keep saying the video is not admissible?
Because a movement for summary judgment has to establish that it's admissible with either chain of custody or that a
Well,
witness.
didn't someone testified, I read there was an affidavit that said,
Detective Jarvis.
Detective Jarvis, yes.
He didn't get the video. He never said it was accurate, and he never got it from the gas station system. We don't know who got it, who stored it at the NYPD, how they stored it, what system they used, and our expert said it was not reliable because it was tainted, it was distorted when plaintiff's expert changed it from one software to another software.
Okay. Any other questions?
If there are no further questions, I'll wait until rebuttal.
Okay, thank you very much.
I'm not sure
How was
which
the video
red herring
obtained?
to address.
How was the video obtained? The video, how was it obtained?
Okay, the video was obtained from the police.
From the police.
What occurred was, the estate was never notified of the DMV hearing. When Mr. Deeb appeared for deposition, he stated for the first time that he testified at the DMV. The defendants would not voluntarily provide us with the information so that the transcript could be obtained. It took a number of discovery conferences and orders before a copy, we were given the information to obtain the DMV transcript. When we got the transcript, it made mention of the video. And then efforts were made to get a copy of the video, which the defendants always had from the city police department, and that's how it was obtained. At the DMV hearing, though, Detective Jarvis did testify that he did go to the gas station. It was downloaded by the police. It was found to be accurate in terms of content and time stamp, and it was properly gathered by the police department in accordance with existing case law that permits a police officer to establish the chain of custody of a video. The defendants have chosen to use the video when they want to and not to use the video when they don't. The bottom line is they have had the video from the beginning, and we had to go search for it in order to have it. But it was authenticated by
Their expert, forgetting about even the admissibility, their expert did raise questions about whether there was some distortion that might affect exactly what the speed limit was, correct?
I think the speed limit is a secondary
Not the
issue
speed limit,
here.
the speed that the defendant was going.
Their expert did not dispute the content, the subject matter of the box truck and whether she came out from behind it. What he disputed were the slices that were made and whether the way they were made could accurately be used to extrapolate the speed of the
So there were issues of fact, so even if it were admissible, this would be something that would be discussed.
Not on the content, Your Honor. The content has been established, and the content makes it clear, as the court below saw, was that the excuse for his failure to see was not a real excuse, that there was no box truck. They have never been able to explain how she jumped from behind this white box truck, which had nothing to do with the accident. All we're seeking here is summary judgment, partial summary judgment under Rodriguez. We're not asking for a
No,
percentage,
I think we understand that.
merely that there is a finding of negligence against the defendant, and all other issues, as the court below recognized, are issues of comparative negligence, which should be deferred for trial.
Okay, thank you very much. Counsel, you have 2 minutes.
I'll be quite brief, Your Honor. Just a few points. I would say that the plaintiff waived any discovery issue by filing the note of issue without ever asking us, not even one time, for the video or any video in the case. They always had access to the video because it was a public record. That's where they eventually got it. 2 months post note of issue, they got it.
Did you have it? You're saying they never asked you for it? You had it, you didn't tell them you had it, and then they never
We
asked
got
you
it.
for
We got it at some point during the case, I can't say exactly when, but we did have it, but they never one time asked us for it. And our expert told us it was tainted. That's why we didn't use it in our motion as attached to our motion. As for this, I can't overemphasize enough, the box truck was involved. She keeps saying it's not involved. It's, according to her expert, 104 feet away within the same intersection. That's only 2.5 seconds away. So to say that it's not involved is just contrary even to what their expert and what
That's what your driver testified to.
Exactly. His testimony is consistent with the video that box truck was on his left. By the way, this video is from the vantage point of the side. It's not showing his vantage point. And also, the chain of custody argument that counsel just made for the very first time in a reply brief on appeal. Very first time. Can't be considered. It's not accurate anyway. The court looks at the DMV record. If there are no further questions, I'll rest on my brief.
Okay, any more questions? Okay, thank you both.
Thank you.
Elecna versus 207-217.
Good afternoon, Roger Sacker, Newman Ferrara. May it please the court. I'm hoping this one is fairly straightforward. The Santa Maria affidavit's at 494. I don't know why the court refused to consider it. It's unrebutted. There's no dispute that he lived in the apartment. My adversary presented no argument about the Santa Maria affidavit. I don't know what the court was doing. The 4-year rule issue, Justice Friedman and I discussed this a couple weeks ago in Woodson. If we hold that this idea that damages cut off the moment you file a complaint, we're going to just have serial complaints. We've already had to file another one in this case. There's no logic to that determination. No court has ever held that. DHCR doesn't hold that, even in Regina, which is what the court below cited for this proposition. It says nothing like that in Regina. They've awarded something like 20 years worth of damages. I don't think the argument's premature. Obviously, we don't have a ruling from the court below, so let's get one here, open up the 4 years, and open up beyond 4 years, and get a correct ruling below. Any questions? All right.
Well, if we think of any, we'll ask you on rebuttal, okay?
Good afternoon. May it please the court. Michael Cruz from Hunt and Andrews Kurth, representing respondents. Appellants seem to think that this appeal is about whether they can receive post-complaint damages in this case, and whether Mr. Santa Maria adequately established his tenancy. That's wrong. If they wanted to do that, if they wanted the court to address those issues, they could have appealed the summary judgment decision in which those issues those decisions were made. Or they could wait until Supreme Court issues a final judgment in this case and actually determines whether respondents are liable and if they award damages, if any. Or they could also await this court's decision in Woodson, which is now pending, and which the court about the recovery period is squarely presented. Instead, it appealed the denial of a motion for re-argument or renew those issues. As such, this appeal turns on two very different questions. Did Supreme Court deny appellant's motion for leave to re-argue, for which there is no appeal, And did the Supreme Court properly apply its discretion in denying appellant's motion to renew? The answer to both of those questions is yes. The rule in New York, of course, is that there is no appeal from the denial of a request for leave to re-argue. Now, appellants say they get past that rule because Supreme Court essentially granted re-argument by engaging with the merits of their argument. That is not true. On the issue of the recovery period, appellants argued at record page 1002 only that they were entitled to post-complaint damages because they continued to pay rent after they filed the complaint. In denying the request for leave to re-argue, Supreme Court made no reference to and did not address that argument at all. There simply was no re-argument of that issue, and so the exception appellants rely on does not apply. The same is true on the issue of the Santa Maria tenancy. Supreme Court did not engage with the merits of appellant's argument, such as
But did you agree on those merits? Did you agree that there was a mistake made by the court below in the timing?
It's a matter of record that respondents' prior counsel on the motion did not object to that. And Justice Edmeade understood that when she denied appellant's motion. So again, our point here is that on this appeal, we don't get to that question. So with respect to the tenancy issue, there also, the court did not engage any argument that was made by appellants below. It simply observed that the motion included new documents and so did not meet the threshold requirements, 3221D2, that did not include matters of fact not offered on the prior motion. Supreme Court also properly exercises discretion in denying appellant's motion to renew. 2221E2 requires the motion be based on new facts, but appellants offered no new facts on either of those issues. With respect to the tenancy issue, they referred only to a stipulation that had been submitted before. This is at record site 767 through 774. And while they did submit a new document on their motion regarding the tenancy, under Wang v. Frida, that document doesn't qualify as a new fact, since as appellants admitted in their opening brief, it merely confirmed the allegations in the affidavit that had already been submitted. Finally, Supreme Court also correctly found that appellants provided no justification in their motion for their failure to submit the document earlier, as required by CPLR 2221E3. Appellants say nothing in their papers to challenge those findings. Unless you have other questions, I will rest on our briefs.
Okay, thank you very much.
Thank you.
Perfect timing.
Look, we all know Justice Edmeade. She's a distinguished jurist. If she wanted to deny a motion to re-argue, and renew, she knows exactly how to do that. It's one line that says, it's just like what this court does. When you file a post-argument motion, you deny it in one line. She clearly engaged with these issues. It was something like 30 pages. If this isn't granting essentially a motion to re-argue, I don't know what is. That's all I have, unless anybody has any questions.
Okay.
Thank you. It's been a pleasure.
Thank you both very much. Have a good day. People versus Williams, please.
Good afternoon. May it please the court, Shayna Watrous on behalf of Key Lester Williams. There was ample reason to doubt the accuracy of the complainant's identification of Mr. Williams. His DNA was excluded from the samples taken from the complainant, but the DNA of an unidentified strange man, not Mr. Williams, not the complainant's brother, was found in the specific parts of the complainant's body where she said she had been touched. There were several other men in the apartment on the night of the incident, men that she didn't know, men that she couldn't identify. And here there was a 12-year-old girl who made a mistaken identification in a scary and stressful moment in her life. And her mistake sent Mr. Williams to prison for years.
She repeatedly made a mistake. She told the police. She told her brother. We can go on and on with this. Mistake? I'm not really sure about that.
Your Honor, her
She
first...
told her mother, she told her aunt. So she repeatedly made mistakes when she told all these people what this person did to her, and then also testified. And her brother corroborated that testimony, but that's a mistake.
Well, I would just note, as to the point about her brother, that they have very different stories about what happened that night. She says that when this was happening to her, and I'm not saying that she was lying about this happening to her.
No, because you said a mistake.
Right, and absolutely this happened to her. It's just about the identification, that she was in a dark room, and she said that she knew it was him because he was wearing a hat. Later, she said she's not sure whether he was wearing a hat. She didn't identify like any other things about what.
What about the blue and purple shirt that she says he was wearing, which is the same blue and purple shirt that he was wearing when she first saw him in the kitchen, and the same shirt he was wearing when she saw him in the room when they were playing video games. And then she goes on to say that she knew him as Lester because that's what, as uncle, because that's what Deshawn, her cousin, would call him.
Mm-hmm. Yeah, she never had a great chance to look at him and identify him before this incident. She said she had gone into the kitchen to get a snack and sort of saw him there, but hadn't talked to him. But what she did see, she saw him a lot after the incident. So if she made a mistaken identification...
What about in the room when they were playing video games? When he came in and he sat on the bed and then he went and took a nap, and she's looking at him. And he's wearing the same shirt that she later describes to the police. This is the person that did, that assaulted me.
She saw him in that room. He came into that room and then went behind her, and she says that she didn't talk to him when he was in the room, and the whole time she was playing video games, she didn't look at him. He was taking a nap. This wasn't like an opportunity.
Your appeal is a weight of the evidence appeal. These issues were certainly matters for the jury to consider. I mean, you point to certain contradictions about the hat. These sort of discrepancies in testimony occur frequently, and it's not a basis to upsetting the jury's credibility determinations. I mean, she's making an identification of someone that she spent some time with in the apartment, that she had clearly had a good opportunity to see at some point over the time that elapsed here.
She had a good opportunity.
What is the basis for this court upsetting the jury's determination? And insofar as the DNA evidence may not support, doesn't contradict, but may not support what she says, the people's expert explained that.
The people's expert said that this was very, very sensitive technology, that they could pick up a trillionth of a gram of DNA if, like her leggings, it was a rough thing. So if he had been rubbing her leggings, one would absolutely expect to see his DNA there. And they fully excluded his DNA from the specific parts where she had been touched. There were other people in the apartment that night. And just to address her description of him about the shirt that he was wearing, she only really had a good opportunity to see him after she had made this identification, and he was brought into the room, and she got to see what he was wearing there. She later saw what he was wearing in the lights of, the flashing lights.
Even if the defendant argued for dismissal of the sexual abuse accounts, he did not specifically raise an identification-based argument downtown, did he? So I'm not even sure this is exactly an argument that's preserved, although you're probably arguing that we can hear it in the interest of justice.
The entirety of his defense, the summation was entirely about the fact that he, hadn't, they had gotten the wrong person, that there was no DNA testing of the other men in the apartment. It's like when they discovered that there was somebody else exactly in the spots where she said she had been touched, they just stopped looking. They didn't try to test anybody else. And his conviction was against the weight of the evidence, and we would ask that it be reversed. Thank you.
Thank you. May we hear from the District Attorney's Office, please?
Good afternoon. May it please the court, Cynthia Carlson for the Office of Darcel D. Clark. The overwhelming evidence at trial established that the nearly 40-year-old defendant crawled into the bed of a 12-year-old girl and sexually abused her. The victim and her 12-year-old twin brother both credibly testified, and they corroborated each other. They also were unwavering in identifying the defendant, and they identified him well before any police involvement. In fact,
What's the explanation for the fact that you don't find his DNA on her, the portion of her clothes that you may have expected to find it?
as the expert testified, that you wouldn't necessarily always find DNA just because you touch something. There are different factors. It depends on how long you touch something. It depends on how much force. It depends on the quality of material, all of which would play a role in this particular instance of not necessarily finding his DNA.
And the jury heard all this, and of course, the defendant had an opportunity to cross-examine your expert.
Precisely. Everyone heard this, the jury rejected it, and their credibility determination should not be overturned on this appeal. As far as excessive sentence, Your Honors, I would just point out that the defendant was on parole for second-degree manslaughter less than 8 months when he committed this instant offense, and he was violating the conditions of that parole. There is no reason to further reduce his already lenient sentence, which is near the minimum of what he could have received both for his incarceratory term as well as his post-release supervision. If there are no further questions from the court, the people will rest on our brief.
Thank you, counsel. You have a minute for rebuttal, counsel.
I would just quickly note that while you would normally defer to the fact finder on issues of credibility, we're not claiming that Zabrion, the complainant in this case, was not credible. She fully believed, she's a smart girl, she fully believed that she, was telling the truth about what she saw and what she believed, and it's just a fact of science that developing a young person's brains, they can have trouble figuring out when they saw something. So if she saw him in the room immediately after she said that this happened, that would only compound if she had been confused about who she saw, not what happened to her, but who she saw. And then there was this later identification where she sees him in these flashing ambulance lights. She would only become sure of herself, and it wouldn't seem to a jury like she was lying because she wasn't. She was just, she had not made the correct identification shown by this very sensitive DNA test. So again, ask for reversal. Thank you.
Thank you, counsel. People versus Angel Diaz. Give you a couple minutes. Good afternoon.
Good afternoon, Your Honors. Ashley Baxter on behalf of Appellant, Mr. Angel Diaz. May it please the court. Your Honors, Mr. Diaz is sentenced to 10 years' incarceration followed by 5 years' post-release supervision is excessive in light of his struggles with his mental health.
This was defendant's 6th felony, wasn't it?
Yes, Your Honor. Your Honor, our argument is that Mr. Diaz could have received the minimum sentence as a first violent felony offender, but instead he received 10 years instead of the minimum 3.5, and he received the maximum post-release supervision of 5 years. Therefore, the sentence he received, nearly 3 times the minimum amount, was excessive. So Mr. Diaz is a husband, father, and grandfather that lost his way because of drug abuse and mental health issues. Although the offense at issue here was a serious one and Mr. Diaz exercised poor judgment, Mr. Diaz did not discharge the weapon, and the complainant here sustained no injuries. Mr. Diaz had confronted
But he did rob him at gunpoint and threatened to murder him, correct?
Your Honor, with regards to the robbery, I believe there is no indication in the record that any stolen property was recovered when the police...
He attempted, is what I said, he attempted.
Because the victim, Alfonso, escaped, right? He drove away from him, right?
Right. But yeah, I also want to note, Your Honor, that Mr. Diaz had explained in the statement of notice why he had confronted Mr. Celentino, the
Yeah,
complainant.
but the people refute that, do they not? I mean, the defendant concedes knowing or claims that he knows the victim and calls him Tony, but the people say that it was actually Alfonso, and that the story, the excuse he gave for why he did this, in other words, because Tony had impregnated someone and wasn't taking responsibility for it, the people don't accept that story that the defendant presented. And they say it wasn't a Tony who was the victim, but an Alfonso who was the victim. Isn't that the competing situation that we have here?
Well, yes, Your Honor, I see my light is on. That is the...
You can answer the Judge Friedman's question.
Oh, thank you, Your Honor. That is the competing story here. However, Mr. Diaz explains that he knew him as Tony and that he had confronted him about impregnating a family member, and that's why he had confronted him. Again, there's no excuse for Mr. Diaz's action, and Mr. Diaz did exercise poor judgment, but again, Mr. Diaz...
The people don't confirm that that's actually what's going on. Am I right?
That he had...
As I read the people's brief, they do not accept that this is actually, that what the defendant told the police upon arrest is really what happened.
Right, Your Honor, and our position is that he had confronted him about this, what he had done to this family member, and so that's why we have these competing positions. There's no express explanation in the record that Mr. Diaz's intent was to rob Mr. Celentino, as the people allege in their brief. Again, there were no stolen property recovered when the police arrested
Well,
Mr.
that's
Diaz.
why the conviction is of CPW too.
Yes, Your Honor, and just to finish briefly, that's why we're asking for his sentence to be reduced to the minimum in the interest of justice.
Okay, thank you very much.
Thank you, Your Honor.
Staten Island Care versus Zucker.
Good afternoon. May it please the court.
Good afternoon.
My name is Theodore Myrans. I represent the petitioner in this case, which was transferred to this court under CPLR 7804G.
Sir, is it your position that it was wrong for them to disallow these, the NAMI, which you believe is a bad debt, and they should have applied the Medicare standard to the Medicaid allocation?
In terms of allowing the bad debts to be an offset against the overpayments, yeah, that is correct.
But there's a difference between Medicare and Medicaid.
Yes, but the New York State plan, which was approved by the federal government, includes 10 NYC RR 18-2.17a, which says that in terms of allowable costs, they will follow, Medicaid program of New York will follow Medicare principles unless there's an exclusionary regulation somewhere else in the Department of Health or Department of Social Services regulations. There is no such regulation that limits this, and as fact, as the third department...
How does that assertion that you've just made square with Florence Nightingale Nursing Home versus Paralysis? I mean, I know that you'll tell me, well, that relates to the federal outlook on it, but isn't it indicative, really, of where the state is going to be, too?
Well, Florence Nightingale did not discuss the issue of whether there was a state law. Florence Nightingale was premised on the fact that New York had no law with regard to uncollected NAMIs. And in fact, Florence Nightingale cited to a Seneca versus Kansas case, which said that in the case where state law does allow for the reimbursement of uncollected NAMI, that's fine. As between the state, Florence Nightingale said basically that as between the state and the federal government may not reimburse it, but the state may be obligated. The Eden Park case in the Third Department, which was contemporaneous and was actually decided after Florence Nightingale was fully briefed, that case said that under 86217A, the state did have to follow Medicare.
Yeah, but doesn't 86217A relate to prospective rate setting and not to reimbursement or recoupment of Medicaid, of NAMI payments which were not collected?
Well, that was the state's argument, is that Eden Park only dealt with rate setting as opposed to audits. However, as our expert testified, as in the record, and in the cases that we have cited and attached to the record, the Department of Health has used 86217 in the audit arena to state that it will follow Medicare principles of reimbursement. So therefore, we believe that we're entitled to that.
Where did they do that?
Well, we cited two cases in our brief. It's in the record. It's the Affinity Skilled Nursing Facility in the record at page 53, and the Susquehanna Nursing Rehabilitation case on page 65 in the record. And we believe, and our expert as well testified that the rate and audits were both treated the same way in terms of 86217. With regard to the interest issue, I would just point out that the state's argument is that we were precluded from raising the interest issue because we didn't raise it in response to the draft audit report. And under 18 NYCRR 51918, we're precluded from raising it at the hearing. The state itself has interpreted that regulation to mean that we can't raise new issues, but we can put the state to the proof to its calculations. And therefore, in this case, since the evidence shows that they charged us interest for 16 days prior to our actual receipt of the monies, and that's based on state documents.
Didn't they say you didn't raise that below, so it's not in the record for us to look at?
They're saying that we didn't raise it in response to the draft audit report. However, as we believe the plain language of that regulation, which limits to the response to draft audit report, as well as the Department of Health's own interpretation of that regulation in the Cleve-Dawson case on page 101 in the record, that says that you can't raise a new issue that wasn't raised below, but you can put the state to the proof of its position. And these calculations are part of the proof of its position, and we're saying that they calculated the interest wrong. Thank you.
Okay. You'll have a couple minutes on rebuttal. Thank you, counsel.
Good afternoon, and may it please the court. Blair Greenwald on behalf of the respondent. As the Second Circuit explained—
So it's your position that 86 2.17 relates to prospective setting of reimbursement, right? That's your position.
That is correct, and it follows the plain language of the regulation.
So if it factors into prospective setting of reimbursement rates, how does it work that NAMI doesn't get factored into that too? Why is NAMI treated differently if it does get factored into prospective reimbursement rates?
So I'd just like to be clear here. We are not saying that these particular NAMIs were factored into the reimbursement rates. All that we were saying is that in order for 2.17 to apply, someone would need to try to include these kinds of debts in their cost report for the calculation of reimbursement rates. But more generally, the issue here is that the regulation was issued in a very narrow context to say, we are going to allow some costs for the determination of rates that Medicare allows in its determination of rates. What the regulation does not say is that we are going to reimburse for paid claims under Medicaid everything that Medicare reimburses. And there are very good reasons for that. In particular, federal law, while it authorizes some Medicare reimbursement, federal law itself, as the Second Circuit explained, indisputably does not allow for Medicaid reimbursement. And the analogous state law regulations say exactly the same thing. There are distinct purposes and resources for both Medicare and Medicaid. Medicare is allowed for entire categories of people who do not need to satisfy income requirements, whereas Medicaid is reserved for the truly needy and requires conservation of resources for that purpose. I'd also just like to note, as a matter of scale, what Medicare might cover in this NAMI debt context for nursing homes is very limited because Medicare coverage generally doesn't cover nursing homes at all. It may require some...
For the petitioner referenced 2 cases which he claims to allow such reimbursement. What is your response to that?
That's not true. Like Eden Park, those DOH determinations are only in the context of rate determinations, not direct reimbursement like petitioner is asking for here. And actually, both of those DOH determinations also have nothing to do with NAMI debt.
Before your time is up, I want to turn your attention to the interest question. You get interest from the time of the processing date of the payment, is that correct?
Well, unfortunately, while that's not clear on the record here, I have independently confirmed with OMIG that generally what they do is work from what shows up as the paid date on the audit report form. And what that paid date refers to is the date that the claim is adjudicated as the funds belonging to the provider.
Let me try, because it gets very confusing when you talk about all of these different dates, but let me try to ask the question in different ways as I try to understand this. Obviously, a check is written by Medicare at some point to someone such as the petitioner, right? Or there's a determination made to make a payment to the petitioner.
I'd like to just explain it as a matter of process and give an analogy, because I think that'll be easier. What happens is the provider submits a bill to Medicaid. Medicaid receives the bill, adjudicates it, and approves it. The date that it's approved and the provider is legally entitled to that fund, those funds, that's the paid date that shows up on the audit report form.
Is that the date from which interest is going to be charged?
Yes.
So why should that be? Because clearly, someone situated such as the petitioner has got, I'm sure, several days, if not weeks, before they're actually going to get that check.
For 2 reasons. One is that just as a matter of administration, it's completely not feasible for the huge Medicaid system to track when every individual provider actually has their funds in hand for every overpayment.
That's a good answer. That's a good answer. But again, clearly the petitioner is not getting that money the day that you decide to pay it.
That's where my other answer comes in?
Yes.
At the time the claim is adjudicated, which is the date that OMIG starts applying interest, the provider already has a legal claim to those funds. Medicaid has said those funds are yours. So it's
But they don't have them.
It's akin to an employee who at the end of the pay period is, they have their payment adjudicated, those funds are theirs, but they may not actually receive their check in the mail for several weeks. That's precisely what OMIG is doing here.
But the difference, of course, is that you're charging interest, and in the employer-employee situation, there isn't an interest going on. There isn't an interest payment involved.
Assuming there's no overpayment. But I'd also just like to note that the provider
it just seems that there's a certain inherent unfairness in you're deciding on, let's say arbitrarily, May 1st, you're entitled to the money and we're going to pay you, when it's clear beyond any doubt that that money is not ending up in the recipient's hands before May 10th.
So both as a matter of administration and the fact that the agency is interpreting its own regulations in the reasonable way that it has here in order to allow the Medicaid system to operate efficiently. I mean, this is a behemoth, very complicated system. It has reasonably interpreted its regulation that way. And I will also note that it is the provider that has submitted the bill to Medicaid and claimed those funds in the first place. So they are saying,
you mean
we have a right.
You mean it's their fault and therefore they should bear the brunt of it?
I mean,
basically.
essentially, that's why the interest is being applied in the first place, yes. They asked for that overpayment, they got it, and they are not entitled to it. If the court has no further questions, we would urge the court to affirm for these reasons and those stated in our brief.
Okay, thank you.
Just two quick points. In response to Justice Friedman's question, it's not difficult for the state to determine when the monies are released. The cycle calendar, which the state publishes, which is Exhibit U in the record, actually says the release date, which is 16 days after the check date. So at a minimum, they know when and it's generally electronic funds, so it's not, you don't have to worry about mail. They know when that money was released to a provider. So that is not an issue in terms of the calculation. And also, I would just point out that the state has not shown any basis in the regulation to treat NAMI differently from any other allowable cost under 86217A. If there are no further questions, I'll rest on the briefs.
Thank you.
Thank you.
Thank you both. Sotelo versus TRM Contracting?
May it please the court, Ephraim Morton-Towle for the appellant. The facts should be fairly simple. There's indisputed that there was an excavation for the purposes of reaching the foundation to waterproof it. This excavation was 5 feet deep, 3 feet wide, and extended for the length of the building. Mr. Noto, the project manager for TRM, the general contractor, testified that that existed there, and it was waterproofed with this black tarp.
There are pictures in the records. Is it your position that those pictures reflect the ditch having been repaired?
That's the ditch after they already put in cement flags into the ground.
It's not complete. The pictures in the record don't show the ground completely covered.
Not complete,
but it shows a very small area of sand.
Sand that was filled up already. It's a later stage of the project.
Flags of cement around it.
Right. But that's not,
But that's post-repair photos.
Correct. The plaintiff testified that's post-repair. That was just attached for the purpose of showing location. But the plaintiff testified expressly at his deposition that does not show the way it existed at the time of the accident. At the time of the accident, the cement flags were not there, and the trench was 5 feet deep, 3 feet wide. This is, I mean, it's undisputed that there was an excavation trench for the purpose of accessing the foundation to waterproof it. Plaintiff testified he fell into that trench. There were supposed to be planks in order to reach the restroom. The planks weren't there. Instead, there were
Something else that he thought he was stepping on
Right.
planks. When he stepped down.
Right,
it
he
wasn't
saw the waterproofing material, and it was supposed to have
material.
a cement plank beneath. It wasn't there, and he fell through. That's a very simple set of facts. And the trial court, the motion court, was wrong in saying that, well, we need more discovery to determine who took away the planks. From our perspective, that's absolutely irrelevant because the general contractor and the owner, TRM and Brighton, have a non-delegable duty to have a safe work site. It's irrelevant which of the myriad of third and fourth and fifth party defendants took it away. They're responsible because there was this ditch that was not guarded. And Mr. Noto himself, the project manager, said it was supposed to be guarded. There was a company called Capital Interiors that was supposed to put gates around it and take care of that, and it wasn't there. This is undisputed testimony. And as I said, it's irrelevant as to who took it away. It's a non-delegable duty. And then rest on my brief. Unless the court has any further questions for me.
Not at the moment. Thank you.
Good afternoon, Your Honors. C. Briggs Johnson for the defendant's respondents. I quibble with the characterization of the evidence from TRM and plaintiff's employer that it's undisputed that the excavation ditch was there and it was 5 foot deep and it was 3 feet
Well, what
long.
evidence do you point to that there wasn't a ditch there?
So,
What's your page reference that there wasn't?
Right. So, and I think there's two things to keep in mind as I present this evidence to you. One is the procedural burden for plaintiff and that I'm entitled to as the non-mover in a summary judgment, right? I get the benefit of the most favorable light of all the evidence and also, even if the evidence is circumstantial in my favor. And two, the progress of the project. Now, Mr. Noto, who was the superintendent for the project, testified that specifically was asked, was there a ditch or a hole, excavated
He
trench?
didn't remember, right?
Well, he said he was specifically asked on 624 of the record, in June of 2014, was there a hole or a ditch that existed on the side of the building? He said, not per se, not per se. And he went on to elaborate that there never should have been any holes that of those dimensions that plaintiff
So what he
described.
goes on to say, to finish his answer on
Yes.
page 624, he says, no reason to be a ditch. That's hardly a denial. I mean, Noto has an important role on this property, right?
Right.
It's very easy to say, and no, there's no hole there.
That's true.
There shouldn't be. I mean, I understand when you say you're entitled to the most favorable inference.
Right.
But, we have to read this in a plain English sort of way, don't we? And that's not a denial that there's a ditch there to say that, no, there shouldn't have been a ditch.
It's not an outright denial, I agree with you, but he does go on to say that at this stage of the project, that no hole, the dimensions, the size the plaintiff was talking about should exist on the side of the building.
Maybe it shouldn't exist, but that doesn't mean it doesn't exist. And I thought he went on to say he doesn't remember if it existed. So I don't think that's a very definitive answer, like, no, there's no ditch.
That's fair, but also
he goes on to say because they have everything involved was there and they filled up, maybe could have been not a ditch, but a little slope towards the retaining wall, but not a ditch per se. So, and
he also says, the plaintiff is describing this hole, right, as 5 foot deep, 3 feet long, the entire side of the building. He's talking about holes for plants
well,
on
there
the side of
was
the
a
building.
digging down, was there not, to get down to the foundation, I suppose to waterproof the foundation? This tarp material was being used against the concrete of the building, against the
Right, there's a slope, but that's completely different than a giant ditch. And also, I think it's important to keep in mind plaintiff's position, right?
That's why if there was no ditch there, I mean, you would have expected Noto to say there was no ditch there.
Not per se.
Yeah, listen, I will say two things. One, this was a transfer file. Two, I looked at this before the summary judgment deadline. I think Mr. Noto had passed away, okay? But I think it's also important to know plaintiff's position on this appeal is that this is the only place where the bathrooms are, right? This is the only bathrooms, and Mr. Noto and plaintiff's employer was specifically asked, was there a hole or a ditch in the project? He said no. They had to go across this ditch every day, right? If they were going to use the bathrooms too, they were.
Well, it had previously had wood planks on it, which made it safe to go across.
Which is
but
why the
someone had
guy
removed
thought
it
they were still.
removed it this day and put a tarp there, which he fell through.
I understand what you're saying, and I respectfully disagree with the interpretation of the. But I think in terms of the summary judgment burden and thinking about yes, could their answers have been 100% better? Absolutely, but it is Labor Law 240 is basically strict liability in most circumstances. I think there's enough here to at least send this case to a jury on that question. And I rest on my arguments in my brief unless there's any more questions. Thank you.
Thank you very much, counsel.
Okay. With respect to plaintiff using that bathroom, he was never instructed not to use it, and he had every reason to presume that the black tarp that he walked on was properly secured when he went there, as he went there many times in the past. With respect to the existence of this excavation, this trench for the foundation, it's at page 1180 of the record that Mr. Noto explains in detail. Say they excavated, they built a wall around the excavation, they've put a slab on the bottom of the excavation, they waterproofed the outside wall, and that's the extent more or less of the work. And even defense counsel in their papers before the motion court, it's page 2024 of the record, paragraph 15, it says an entity named Catalyst Construction was responsible for all excavation and foundation work of the project. Its Catalyst dug or excavated trenches around the foundation of the building at some point prior to plaintiff's accident. So it's no dispute. They dug this trench for the purpose of waterproofing the foundation prior to the accident. This is undisputed. It's page 2024 of the record. It's their own papers. Thank you.
Thank you. Thank you both. No, not yet. We got one more. All be seated. It's okay. It's okay.
Yeah.
That's all right. We appreciate your.
You've been here a while.
Thought, my goodness, we're not going to get hurt after all that. No, I specifically granted time to you, so we can't take it away from them.
Thank you very much, Your Honor, and I'll endeavor to be concise and compelling.
Thank you.
My name is Patrick Walsh of Stolberg and Walsh on behalf of the appellant, Ms. Gina Ridgey. The Supreme Court's conclusion that Ms. Ridgey's work as a makeup artist on The Charlie Rose Show qualified her as exempt under the labor law as a professional addressed an affirmative defense inappropriately on a 3211 motion. This was a motion filed before any discovery had been taken place, and of course the defense of an exemption is very fact-intensive. There are several other reasons why the court committed reversible error in making this determination. First, the plain language of Section 193, under which Ms. Ridgey moves for these labor law misclassification claims, does not contain an exemption. The exemption was imported from Section 198C. This is something that the Court of Appeals in Pachter has advised is not appropriate. Exemptions are to be found only where the legislature wrote them and placed them. And it's a basic tenet of statutory construction that where the legislature includes exemptions in some provisions, but not in others, it does so knowingly. So there's no exemption in 193 to begin with.
So you don't really challenge the 198C analysis that your client made more than $900 a week. My understanding is she got like six-figure salaries.
We're not challenging that if that portion of the exemption might apply. If the exemption did apply, there's a whole other problem, which is that there's a test to determine who's a professional. And the court below didn't even consider the test. It includes a number of factors which...
Didn't she say she was an Emmy Award-winning makeup artist who had studied at the Boston Conservatory of Music, and she worked for many, many years, 30 years, including for this show for over 20 years, or approximately 20 years. I mean, she herself made herself out to be a professional. Now you want to say she's not?
Well, Ms. Ridgey, she's not a professional under the test. What I'll say is Ms. Ridgey's a very talented person, she's a very serious person, and she's been in this business for a long time. And like a lot of people, if they draft a CV or put up a website, they're going to highlight their achievements and their accolades. That's not the standard that the Department of Labor has promulgated to determine who's a professional. The standard involves knowledge of an advanced type in a field of science or learning, the type that's acquired through a prolonged course of study. Typically, this applies to people like lawyers and doctors. There's no case that's been shown by the court below or by opposing counsel applying this to a makeup artist. The second portion of that standard is whether the work is creative in character rather than cookie cutter, as Ms. Ridgey attests, whether it's in a recognized field of artistic endeavor. There's no showing. This would be a factual question anyway to be resolved on summary judgment. Whether the work, the duties of the job, which is really what you're supposed to focus upon, whether they're involved primarily invention, imagination, or
I mean, if they give Emmy Awards and, for this type of work, and they do, I watch them on TV, I see they do, it requires some kind of skill, otherwise anybody off the street could be putting makeup on people's faces. We know that doesn't happen. We know that's a cherished job and that you can win an Emmy Award for it. So I don't see how it's, how you can really argue that too seriously.
Your Honor, first...
Particularly since she also alleged that she did makeup for presidents, other politicians, celebrities.
That's not the standard, Your Honor. And first of all, she didn't win an Emmy Award. In 1995, she was nominated for one on a different show. She's talented. That's not the question. If someone was talented and had accolades over the course of a 30-year career, if that made them a professional, there'd be a lot of professionals under the labor law test exempt.
But the thing is, she worked there for so many years and she never raised this situation I mean, she functioned as an independent contractor, not as an employee. All of a sudden, 20 years later, said, "Oh, I should get all the benefits of being an employee." When that really was not how the modus operandi was for all the years she worked there.
Well, those questions go to the actual merits of the claims, and there's a test for that too. It's called the Beinog test that the Court of Appeals has established. It has to do with control, and whether or not someone knows they're an independent contractor or not, or understands the law, is not a factor in that test. There's a reason why the legislature has enacted labor laws to protect people in these circumstances, and why the courts have established standards to assess them, and don't simply trust employers to determine based upon whether someone submitted an invoice. Under the Beinog standard, the Court of Appeals has made it clear that if one of the allegations of your misclassification is that you were not on payroll, then the element as to whether or not you were on payroll is of limited utility. So all we're asking is that these issues be analyzed under the legal standards that are well established. These are not controversial standards. There are no decisions that say they don't apply. These are the basic standards for determining the exemption. I see my time has run out, Your Honor.
Yeah, you'll have 2 minutes on rebuttal, so why don't you just save it? Thank you.
Good afternoon, may it please the court. This is Cynthia Arado, and I represent the respondents, Charlie Rose Inc. and Charlie Rose. On the question of whether Ms. Riggi is professional, there is no disputed issue of fact. What Riggi characterizes as a disputed issue of fact is just her asking the court to let her take back her binding judicial admissions in her complaint. She didn't make these admissions on a resume or a website. They're in her pleading, and it's replete throughout her pleading that she's a professional, that she exercised judgment and discretion, and that the success of the show depended on it. So I think that she's clearly a professional under any standard, and she can't walk back what she put in her complaint for whatever strategic reasons she felt that those allegations should be in there. But there's also an independent reason why the claim fails, and all of these grounds apply whether or not she's an employee or a contractor. So that's really, I think, a side issue for what the court is dealing with today. And the other ground is that she can't plead and has not pled any contractual entitlement to the benefits that she's claiming should be she should obtain.
Her claims seem to be mostly premised on the fact of what she's seen other employees get.
That's right. And well, there's two reasons why her claim fails. One, she submitted invoices, as the record makes clear, asking to be paid some set of compensation. And none of that included any of the benefits that she's seeking. And she got paid all of that in full. So by her own conduct, it is clear that she had no expectation of receiving any additional benefits. That's why that evidence is before your court, before your honors. It's not to prove that she was properly an independent contractor or not, even though we believe she was. It's to show the compensation that she asked for and received and was expecting. And then that, I think, forecloses any ability for her to claim she had an entitlement to these benefits. But in addition, she makes clear that she's saying it's only she believes other employees receive these benefits, and so if she was properly classified as an employee, then she would receive them as well. And I think the courts, as you see in our brief, have rejected that theory, and among other reasons, and the Gustafson case explains this, had her compensation been negotiated as an employee, it would have been negotiated differently. Employers factor in the full costs of an employment package, and so it's impossible for her to say that if only she was classified as an employee, she would have received both her base compensation that she got paid and these other benefits. And I think the courts, reject that. So the claim fails for that reason as well. And then the claim also fails because there's not a remedy under these labor laws, at least through the passage of the new No Theft Wage Loophole Act, for a wholesale deduction from wages. And the First Department and other departments have made that clear, and there's no basis to apply that new statute retroactively. I just want to point out that the plaintiff cites two cases where we say this court in Overton implicitly held that that statute is not retroactive. And the only cases that the plaintiff cites to are trial court cases, and they don't reach valid rulings. The Colchin's case improperly looked to the remedial nature of the statute to find that that in and of itself was controlling on the question of retroactivity, but that is incorrect, and that's been rejected by the First Department as a proper analysis, and the Quallen case actually didn't hold that anything was retroactive. And I would point out that there's a case that's only recently now available on Westlaw, although it was decided in August, Hensel versus Best Pass, and that's 2022 Westlaw 175-88799, and the trial court there found that this new statute was not retroactive for basically identical reasons that we've put forth in our brief. So if you have no further questions, we'll rest on our papers and this argument.
Thank you.
Thank you.
Counsel, you have 2 minutes.
Your Honor, this case is nothing but disputed issues of fact, and that's what courts have repeatedly said an exemption analysis involves. Some of the disputed issues of fact: did Ms. Ridgey attain heightened knowledge through a prolonged course of study? Is her work original?
But she says in the complaint, paragraph 26, that she's a member in good standing of the New York Women in Film and Television, and which requires accreditation and peer sponsorship for membership, and the International Alliance of Theatrical Stage Employees, which requires passing an examination demonstrating requisite professional skills for membership.
That's not knowledge of an advanced field of science or learning, and it's not attained through a course of prolonged study. There's a reason why there's a standard, and the Department of Labor has applied it repeatedly, and so have the courts. This is not new law. It's been in existence for probably half a century, and the courts have also said that a person's own assessment of whether they're good at their job, whether they're talented, is not a factor to be considered. What the court should consider are the duties that the person performs. And the duties that are performed here are entirely subject to factual disputes. Ms. Ridgey alleges that she was closely controlled. She had no room for creativity or for exercise of discretion in application of makeup. Her schedule was set for her. She was provided the cosmetics she was supposed to use. All the indicia of control demonstrate both that she did not exercise discretion and didn't meet the professional exemption test, and also goes to the merits of the case, that she's an employee rather than an independent contractor. She should not be stopped at the starting line on a 3211 motion. She should be permitted to have basic discovery on these issues so that they can be assessed on summary judgment. Maybe that might be an appropriate time to dismiss the claims if she can't show disputed issues of fact then, not at this stage of the litigation.
Okay, we will take another look, and thank you all very much. And now, thank you, Lieutenant.
Thank you. Nice to meet you. How are you? Oh, yeah, sorry, I'll just wave. Yeah. Well, yeah, good, nice to see you.